He changed the locks at 9 o'clock in the morning. Not the afternoon, not the following week, when the grief had settled enough for conversations about practicalities, about solicitors, about what Margaret would have wanted. 9 o'clock, the morning after they buried her, before the flowers on her grave had begun to wilt, before Patricia had finished her first cup of tea in a house that no longer felt like anyone's home. The key wouldn't turn. That was the first thing Patricia noticed, standing on the front step of the terraced house on Holbrook Lane where she had grown up, where she had learned to ride a bicycle in the back garden, where her mother had kept the same floral welcome mat for 31 years. The key she had carried on her keyring since 1987 simply would not turn. She tried it twice, 3 times. She stepped back and looked at the door, and then she looked at the lock, and she understood with the particular clarity that comes when something is too strange to misread that the lock was not the same one she had used the day before. Ryan had been inside. She could see the light on in the front room. That moment, standing on that step, in the pale gray light of a February morning in Coventry, with a casserole dish in her hands because she had been bringing food for her brothers because that is what you do, that is what families do, that moment was the beginning of everything that came next. Every investigation, every court appearance, every forensic report, every sleepless night, every revelation about what had been done to their mother in the final weeks of her life. It all started there, on that step, with a key that no longer worked. My name doesn't matter. What matters is this story, and I'm going to tell you all of it. Margaret Calloway was 82 years old when she died on the 14th of February 2019, Valentine's Day, which she had always found quietly amusing, because Dennis had never been much for romance, but he had always remembered it, every year without exception, until his heart took him in 2001. She had kept his card from that last Valentine's. It was in the top drawer of her bedside cabinet, in a small envelope that still smelled faintly of the tobacco he had given up 10 years before his death. She was the kind of woman who kept things, not hoarding, keeping. There is a difference, and Margaret understood it. She kept what mattered and she let go of what didn't, and across 4 decades of widowhood she had made that quiet discipline the cornerstone of a life that was, by any honest measure, a good one. She had lived on Holbrook Lane for 44 years. She knew her neighbors by name and by history. She had a routine that she maintained with the cheerful stubbornness of someone who had decided long ago that routine was not a limitation but a form of freedom. Monday was shopping. Tuesday was her friend Eileen from the church group. Wednesday she cleaned properly, top to bottom. Thursday she watched whatever she'd recorded that week and ate whatever she fancied for tea without any comment from anyone about it. She had 3 children. Patricia was 54. She was the eldest, and she carried that distinction the way eldest children often do, with a combination of pride and low-level exhaustion that she had never fully examined. She lived in Solihull with her husband Graham, worked part-time as an administrator for an NHS trust, and visited her mother on average twice a month. She would tell you if you asked her that she felt guilty about that number. She would also tell you that 2 visits a month is what her life allowed. Both things were true simultaneously. Most of us understand something about that. The gap between what we intend and what we manage when it comes to the people we love. Brendan was 51. He lived in Leeds, which made everything harder by geography, and he had built a steady and unremarkable life around a structural engineering firm he'd been with for 22 years, a wife named Carol, and 2 boys who were now at university and barely needed him for anything except money. He spoke to his mother every Sunday. He visited at Christmas and for her birthday in June. He told himself that was enough. Some days he believed it. And then there was Ryan. Ryan was 47. He was the youngest and the most complicated, And if you had met the Calloway family at any point in the 15 years before Margaret's death, you would have known, not necessarily because anyone said it directly, but because it was present in the way conversations paused around him, that Ryan's story had not gone the way anyone had hoped. Two businesses that had failed in ways that cost him more than money. A marriage to a woman named Joanna that had ended badly in 2014, in a flat in Birmingham that was later repossessed. A series of fresh starts that had each begun with genuine energy and ended with a phone call home. Ryan told anyone who asked that he'd put his whole life on hold to be there for her, and by the time she needed him most, he never left her side. He said that at the funeral, standing at the front of the church on Holbrook Lane, in a suit Patricia had not seen before, speaking into a silence that the congregation was too polite to break with the questions some of them were already forming. He meant it as tribute. He meant it as the defining statement of who he was and what he had done. Nobody in that church knew yet what the prosecution would later make of exactly those words. Ryan had moved back into the family home in August 2017. Margaret had been struggling, not catastrophically, not yet, but visibly. She'd had a fall in the kitchen in June that hadn't broken anything but had shaken her confidence more than she admitted to her GP. Patricia and Brendan had discussed, in the careful language of adult children who live elsewhere and feel guilty about it, what to do, and Ryan had offered. He was between things, he said. He had some time, he could be there, he could help. Patricia told investigators later that she had felt, at the time, a complicated mixture of relief and unease. Relief because something needed to happen and Ryan was willing. Unease because, and she had difficulty articulating this precisely, Ryan's willingness had a quality to it she couldn't name. An enthusiasm that felt slightly too large for the situation. But she pushed that feeling aside, because that is also what families do. In those early months, the arrangement seemed to work. Margaret's GP, Dr. Anand Sharma, who had been her doctor for 11 years and knew her well enough to notice things, recorded in his notes from September and October 2017 that Margaret appeared more settled than she had during the previous winter. She was eating properly. She was getting out. Ryan was driving her to appointments. He was cooking. He was keeping the house. Dr. Sharma also noted something else in those early months, something he filed without particular alarm at the time, because on its own it seemed small. Margaret had mentioned during a routine appointment in October 2017 that she sometimes felt confused when she woke up in the mornings, more confused than she thought she should. She'd laughed it off. She'd said she was probably just tired. Dr. Sharma had noted it, suggested she monitor it, and moved on. He would remember that note 18 months later with the specific horror of someone who wishes they had asked a different question. What exactly was Margaret experiencing in those early mornings? And when did it begin? Those questions would not have their full answer for another 2 years. Margaret's estate was worth approximately £310,000 at the time of her death. The house on Holbrook Lane, a 3-bedroom mid-terrace in a quiet part of Coventry, had been valued at £228,000 in 2018. There was an investment portfolio of around £52,000 that Dennis had established in the 1990s, and Margaret had maintained with the same quiet discipline she brought to everything. And there was a savings account, her own, always in her sole name, built from the pension she had received since Dennis died, from the careful management of what she had and the consistent refusal to spend what she did not need. That account held £31,000. For Patricia and Brendan, the estate was not primarily a financial matter. It was the last formal record of their parents' lives. The house meant memory. The money meant security they were not desperate for but would have been grateful to receive. The will, the one their mother had made in 2014, in front of a solicitor named Corinne Doyle at a firm in Coventry City Center, which divided everything equally 3 ways, felt to both of them like the appropriate conclusion to a life that had tried, as best it could, to be fair to everyone. Ryan knew about that 2014 will. He had known about it for 5 years. What he had been doing during the 18 months he lived with Margaret, what had changed between the beginning of that arrangement and the morning the locks were changed, is the question that sits at the center of everything. Let me take you back to the morning of the 15th of February 2019. Patricia drove to Holbrook Lane at 8:45. She had the casserole dish. She had her key. She had no reason to expect anything other than the ordinary grief of the morning after a funeral, the specific emptiness of a house where someone used to live and now does not. The key didn't turn. She rang the bell, she waited, she rang it again. Ryan opened the door after 2 minutes. He was dressed. He looked, Patricia would say later, like a man who had been waiting for her to arrive. "Morning," he said. "The lock's been changed," Patricia said. "I had it done yesterday," Ryan said. "Security, while we were all at the church. I was worried about the house being empty." Patricia would later describe the precise sensation of that moment, the way the explanation arrived so quickly, so completely formed, that it had the texture of something prepared. "He had an answer before I'd finished the question," she told investigators. And the answer was fine. It was a reasonable answer, but it arrived wrong. In her witness statement, Patricia described what happened next in these exact terms. She said she stepped inside the house, and Ryan followed her to the kitchen, and on the kitchen table there was an envelope. She said she noticed it immediately. She said it was the kind of envelope you recognize, cream-colored, slightly thick, the kind that comes from a solicitor or a bank. She said Ryan watched her looking at it. She said he let her look at it for about 5 seconds before he spoke. "Oh, there's something you need to see," he said. He picked up the envelope and handed it to her. Inside was a document, 11 pages, typed with a signature on the final page. A will. Dated the 17th of March 2018. Margaret Ellen Calloway of Holbrook Lane, Coventry, leaving the property and all its contents to her son Ryan James Calloway, outright and without condition. The investment portfolio. A different clause left to Patricia and Brendan in equal shares. The savings account, and this was the detail Patricia nearly missed, because she was still processing the property clause was not mentioned. Because by the time Patricia read that will, the savings account no longer existed in a form that could be bequeathed. Ryan had moved the money. Bank records obtained during the investigation confirmed that 2 days before Margaret's death, on the 12th of February 2019, when Margaret was, by her GP's account, barely lucid, Ryan had transferred the entire balance of her savings account into a joint account that bore both his and Margaret's names. A joint account that Margaret, as far as Patricia and Brendan had ever known, had not previously held with anyone. He had moved the money into a joint account while she was still alive, meaning that when she died, it passed to the surviving joint account holder automatically. No will required, no probate process, no question of division. By the morning Patricia stood in that kitchen, Ryan Calloway had, in the space of 48 hours, changed the locks, produced a will that gave him the house, and moved £31,000 into an account that was already legally his. Patricia stood in that kitchen for a very long time. She said afterward that she could hear the house, the particular silence of a house that knows something is wrong, the faint hum of the refrigerator, the sound of Ryan moving behind her. "When did Mum make this?" she asked. March last year, Ryan said. She wanted to do it. It was her idea. She felt it was fair given everything I'd done. She never mentioned it. She didn't want a scene. And here is the question I keep coming back to, and I want you to sit with it. If you were Patricia, standing in your mother's kitchen the morning after her funeral, holding a document that cut you out of everything you expected, what would you have done in that moment? Would you have confronted him directly? Would you have taken the document and walked out? Would you have said something you couldn't take back? Because what Patricia did was fold the envelope, put it in her bag, say very little, and leave. She called a solicitor within the hour. She did not shout. She did not accuse. She collected herself and she acted. And I think, though you may disagree, that decision, that specific restraint, is what ultimately made the difference between justice and nothing. There was one more thing Patricia noticed before she left. On the kitchen counter, partially obscured by a stack of unopened Post, was a prescription bag from the pharmacy on Holbrook Road. It was Margaret's name on the bag. Patricia registered it and moved on. She had bigger things to process. She would remember it later when the pharmacist's records became one of the most important documents in the entire case. Patricia's solicitor was a woman named Helen Watts, who worked at a firm in Solihull and who had, in the 15 years of her practice, seen enough disputed estates to recognize the shape of this one within the first 30 minutes of the consultation. Helen instructed a forensic document examiner named Dr. Robert Fielding within 4 weeks of being retained. Dr. Fielding was a specialist in question document examination with over 20 years of experience, including work on behalf of the Crown Prosecution Service, and he received the disputed will alongside 12 comparison documents, letters, cards, and a gift tag, bearing Margaret's verified signature from the period between 2016 and 2019. He returned his report 8 weeks later. His findings were precise. The signature on the disputed will bore characteristics inconsistent with Margaret Calloway's documented signing pattern across the comparison set. The pressure distribution was wrong. Margaret had a distinctive heavy right characteristic in her signature, a slight ink buildup on the downstrokes that was consistent across every verified sample and entirely absent from the will's signature. The ink characteristics were also incompatible. While not determinative on their own, when combined with the pressure analysis, they reinforced the examiner's conclusion that the signature had been produced by someone other than Margaret Calloway. Helen Watts read that report on a Tuesday morning in June 2019 and made 2 phone calls. The first was to Patricia. The second was to West Midlands Police. The case had crossed a threshold. What had begun as a probate dispute, a painful but legally conventional disagreement about the validity of a document, was now something else. Something that required different resources, different authority, and a different kind of patience. This is the moment in stories like this one where the clock starts differently. Because now there were investigators, and investigators have access to things that solicitors do not. In the weeks between Margaret's death and Dr. Fielding's report, Ryan had not been quiet. He had spoken to Brendan twice by phone. Brendan, who had not come to the house on the morning of the 15th, and who had spent those weeks in a state of confused misery, not quite believing Patricia's account, not quite defending Ryan, suspended in the specific unhappiness of someone who does not want any version of the truth to be true. There is something almost unbearable about Brendan's position in this story. He is, in some ways, the most recognizable person in it. The middle sibling who wanted everyone to be wrong about each other, who kept looking for the interpretation that meant nobody had done anything terrible, who rang Ryan and listened to the explanations, and almost believed them because almost believing them was easier than not. Ryan's account in those phone calls with Brendan was consistent. Margaret had wanted him to have the house. She had been clear about it. She had felt guilty about his years of hardship while Patricia and Brendan had stable lives and stable incomes. The will was legitimate. He had simply done what the solicitor had arranged. Everything else, the savings account, the timing, was administrative, precautionary, legal. He wasn't taking anything. He was receiving what had been given. And then one of the investigators, a detective constable named Sarah Ockhaffer, who had been assigned to the fraud inquiry, requested Ryan's phone records as part of the financial investigation. Standard procedure. The kind of request that produces thousands of pages of data and requires weeks of analysis. She was looking for communications related to the savings account transfer, for contact with anyone who might have assisted in the document forgery. What she found, buried in a WhatsApp archive from the summer of 2018, was not what she had been looking for, but it would become the most important piece of evidence in the entire prosecution. She did not know that yet. She flagged it and moved on because there was still months of work ahead of her, and the full weight of what that message meant would not be clear until the toxicology review changed the nature of the investigation entirely. 6 weeks before Margaret's death, a single text message, a single sentence. Those facts would not mean what they needed to mean until a pharmacist's records and a second toxicology review had been placed beside them. In October 2019, 8 months after Margaret's death, West Midlands Police commissioned a second toxicology review of Margaret Calloway's post-mortem samples. The first post-mortem, conducted in February, had returned a cause of death consistent with natural causes, a respiratory failure in the context of her age and existing health conditions. That finding had seemed reasonable. Margaret was 82. She had a history of cardiac issues. Her death had not, at the time, triggered particular scrutiny. The second review, conducted by a consultant forensic pathologist at the request of investigators, examined the original tissue samples alongside Margaret's documented medication records. Margaret had been prescribed lorazepam, a benzodiazepine sedative, in October 2018, for a period of increased anxiety that Dr. Sharma had noted and treated cautiously. The prescribed dosage was conservative. The documented dispensing schedule was clear. The pharmacist's records, those records that Patricia had noticed without really registering, on a prescription bag sitting on the kitchen counter, told a different story. Margaret's prescription for lorazepam had been refilled 3 times between October 2018 and February 2019. Her documented dosing schedule should have required 2 refills at most. The third refill, collected in January 2019, represented an additional supply of medication that could not be accounted for within her prescribed dosing regime. Someone had been collecting Margaret's medication in quantities above what her prescription directed. Ryan had collected every refill personally. He had the GP's letters authorizing the collections. He had, by his own account in the care diary he had maintained, administered Margaret's medication each evening as part of her bedtime routine. The second toxicology review found lorazepam levels in Margaret's tissue samples that were, in the pathologist's documented assessment, consistent with chronic overadministration across a period of weeks. Not acute poisoning, not a single lethal dose. A sustained, gradual accumulation that would have produced the kind of confusion Margaret had described to Dr. Sharma. The morning disorientation, the increasing sleepiness, the increasing dependence, and that would, in a woman of her age and cardiac history, have materially accelerated her decline. The pathologist's phrase was precise and careful, contributing to accelerated death, not murder. Not a single identifiable fatal act, but a pattern sustained across weeks that had shortened Margaret Calloway's life. West Midlands Police upgraded the investigation. This was no longer a fraud inquiry. Let me slow down here, because what I've just described deserves to be held for a moment before we move into what came next. Margaret Calloway had spent 44 years in that house. She had raised 3 children in it. She had been widowed in it. She had grown old in it with the quiet dignity of someone who had decided that dignity was not something that could be taken from her by circumstance. In her final weeks, the evidence suggested she had been sedated, quietly, gradually, by the one person in the house with her, by the one person who had positioned himself publicly and consistently as her devoted carer. She had said something to Dr. Sharma in one of her final appointments. He had noted it. She had described Ryan's presence as her lifeline. And then there is a second part to that note. She had begun to say something else. A second sentence. Dr. Sharma's note reads, patient expressed, and then stopped. Said she didn't want to worry anyone. Oh, she didn't finish it. We don't know what she was going to say. We will never know. Whatever it was, whatever she was beginning to articulate in that consulting room in November 2018, 3 months before her death, she decided not to say it. Perhaps because she wasn't sure. Perhaps because she didn't want to be wrong about her son. Perhaps because she had come to depend on him so completely by that point that even the thought of naming her fear felt like the destruction of the only structure holding her up. What we know is what happened, what we can document, what the court would eventually weigh. The financial plan had been built carefully and across time. The forged will was dated March 2018, suggesting it had been prepared at least 10 months before Margaret's death, possibly longer. The joint account had been opened in November 2018. The prescription refills had begun accumulating from October. By January 2019, the mechanism was complete. Everything that happened between then and the 14th of February was in the prosecution's framing, and the jury would ultimately agree. The conclusion of a plan that Ryan Calloway had been executing while his mother thanked him for his care. He had attended her GP appointments with her. He had sat in the waiting room while she described her symptoms to Dr. Sharma. He had driven her home afterward. He had on at least one occasion spoken to Dr. Sharma himself about her condition, her medication, her progress. He had been the devoted son, visibly, consistently, in front of everyone who might have asked questions. The specific horror of that irony would become one of the prosecution's most powerful arguments. Sentences become shorter here because the weight requires it. Something was happening in that house. It had been happening for months. Margaret was inside it. She was the only one who was inside it. And she had begun a sentence she did not finish. Detective Constable Sarah Ockhaffer had been with West Midlands Police for 9 years when she was assigned to what began as the Calloway fraud investigation in July 2019. She was methodical. She was, by the account of the detective inspector who supervised the case, the kind of investigator who did not chase the obvious thread, but followed everything back to its origin point and waited for the picture to form. The picture that formed across the following 14 months was one she would later describe, in testimony, as the clearest and most disturbing she had encountered in her career. The morning confusion Margaret had described to Dr. Sharma in October 2017, that note that had been filed and moved past, was revisited in light of the toxicology findings. The timing was relevant. October 2017 was 2 months after Ryan moved in. If over-administration had begun that early, it had been part of the arrangement from almost its first weeks, not an escalation of care into something darker. an intention from near the beginning. That was not a certainty the prosecution could prove to the required standard, but it was a shadow that fell across everything. The financial investigation established the following documented sequence. In March 2018, Ryan had approached a print shop in Coventry with a document he described as a personal letter requiring professional formatting. He had paid in cash. The print shop's records, which were obtained under warrant, showed a transaction on the 18th of March 2018 consistent with the printing of a multi-page document, one day after the date on the forged will. The comparison signatures that Dr. Fielding had used in his analysis included 3 letters Margaret had written in early 2018, one to Patricia, one to Brendan, one to her friend Eileen. All 3 showed the same heavy right pressure characteristic absent from the will's signature. Patricia had provided her letter without knowing its significance. Eileen, 79, retired, who had been Margaret's friend since 1991, had provided hers with shaking hands and a statement to investigators that she'd had no idea what it would be used to prove. Eileen is a secondary character in this story who deserves a moment of recognition. She had suspected, she told investigators that something was not right in the last months of Margaret's life. She had tried to visit twice and been told by Ryan politely that Margaret was resting. She had sent a card at Christmas 2018 that Margaret had not responded to. She had told herself Margaret was tired. She had told herself it wasn't her place. She had carried that decision quietly from February 2019 onward, and when investigators came to her door, she had opened it immediately and told them everything she remembered. The investigation moved through the autumn of 2019 with the particular patience of a case that knows it has the evidence and is building toward a charge that needs to survive the full scrutiny of a courtroom. Sarah Ockhafer spent 3 weeks on the phone records alone, 47 separate contacts with a man named Gary Pollard, a friend Ryan had known since his second business venture, during the period between August and December 2018. Gary Pollard had not been implicated in the fraud. He hadn't known about the will or the bank account. What he had known, what he and Ryan had discussed in those messages, in that casual shorthand of men who think they're speaking privately, was the house, its value, what Ryan planned to do when it was his, where he was going to go, what his life was going to look like. D.C. Ockhafer found the message in October 2019. She read it twice. She printed it. She put it in a folder and labeled the folder with a single word. The message had been sent on the 26th of December 2018. Christmas Day had just passed. Margaret had been alive. She had been in the house. And Ryan had sent a message to Gary Pollard that contained, among the ordinary traffic of a WhatsApp conversation between 2 men catching up over the holidays, a single sentence. We will come to that sentence. Not yet, but we will come to it. Because the sentence matters most when you understand exactly what was happening in the house on Holbrook Lane at the specific moment Ryan sent it. By February 2020, the Callaway investigation had assembled a case file of over 1,400 pages. The financial fraud strand was solid. The document forgery strand was solid. The toxicology strand was the one that kept the senior investigating officer, Detective Inspector Mark Reeves, awake at night. Not because the evidence was weak, but because charging someone with gross negligence manslaughter for the over-administration of a sedative to an 82-year-old woman represented exactly the kind of charge that could be lost in a courtroom if a single expert witness underperformed. The charge of gross negligence manslaughter in English law requires the prosecution to establish 4 elements: that the defendant owed the victim a duty of care, that they breached that duty, that the breach caused death, and that the breach was so grossly negligent that it should be judged criminal. Each element has to survive not just legal scrutiny but jury comprehension. A jury must understand not just that something happened, but that it was criminal, that the line was crossed. That this was not negligence by accident, but negligence so severe it constituted a crime. The care diary was the piece of evidence that tied it together. Ryan had maintained a care diary throughout his time at Holbrook Lane. He had apparently begun it voluntarily in the early months of the arrangement, a record of Margaret's appointments, her medication, her moods, her progress, and he had submitted it to investigators as evidence of his dedication, as proof that he had been doing what he said he was doing, as the documentary record of a devoted son. It was, in Ryan's estimation, his strongest character witness, the diary that proved everything. It became, in the prosecution's hands, something else entirely. D.C. Ockhaffer had been cross-referencing the care diary against other documentary evidence for 6 weeks when she found the entry. The 13th of February 2019, the night before Margaret's death, Ryan had recorded in his own handwriting that Margaret had been settled and comfortable by 8 o'clock in the evening, that he had administered her medication as prescribed, that she had eaten a small meal and gone to bed without distress. That entry was the problem, because the bank records showed that at 7:43 on the evening of the 13th of February, 17 minutes before Ryan recorded that his mother was settled and comfortable in her bedroom, he had used his mobile phone to transfer the remaining balance of Margaret's savings account into the joint account. He had made the transfer. He had written in the diary that his mother was comfortable. He had moved £31,000 in 17 minutes on the night before she died. The diary entry he had intended as evidence of his care became the prosecution's most precise demonstration of the sequence. What he had been doing with his phone while his mother was dying. What his priorities were in those final hours in that house with her. D.C. Ockhaffer described, in her testimony, the moment she placed the bank timestamp beside the diary entry. She said she had been sitting in the incident room on a Thursday afternoon in March 2020 with the files spread across 2 desks. She said she had the diary open at the February 2019 section and the bank records open on her laptop. She said she found the timestamp, looked at the diary entry, and looked back at the timestamp. She said she sat very still for about 30 seconds. Then she picked up her phone and called D.I. Reeves. She said, "I've got it." He said, "How solid?" She said, "His own handwriting." The arrest of Ryan James Calloway took place on the 4th of April 2020. He was brought in for a voluntary interview and arrested at the conclusion of it, when it became apparent that his answers to the questions about the care diary entry were not credible. He said he must have misremembered the sequence of events on the evening of the 13th. He said he might have made the transfer earlier in the day and recorded it incorrectly. He said the diary was not intended as a minute-by-minute record. Each explanation was offered calmly. Each one the investigators had anticipated, and each one had already been foreclosed by the evidence. He was charged on the 4th of April 2020 with fraud by false representation, forgery of a testamentary document, and gross negligence manslaughter. He was remanded in custody. His trial was set for Coventry Crown Court in September 2021, delayed by the pandemic. Patricia had waited, Brendan had waited, Eileen had waited. The house on Holbrook Lane sat empty. The locks Ryan had changed were still on the doors. The trial of Ryan James Calloway opened on the 14th of September 2021, 2 years and 7 months after his mother's death. He entered the dock in a gray suit and sat with the specific stillness of a man who had spent the intervening period preparing for this room. The prosecution was led by a barrister named Catherine Aldridge, methodical, unhurried, and possessed of the particular quality that the best prosecutors share: an ability to present the most damning evidence with a quietness that makes its impact felt more deeply for the absence of drama. Her opening argument took 2 hours. She told the jury that Ryan Calloway had moved into his mother's home with a plan, that the plan had evolved, or perhaps had been present from the beginning, into a scheme to acquire the entirety of Margaret Calloway's estate by fraud, forgery, and financial manipulation, and that the evidence would show that his conduct in the final weeks of his mother's life had crossed from financial crime into something that the law recognized as manslaughter, not because he had intended to kill her, but because his management of her medication had been so negligently administered in furtherance of his own interests that it had materially shortened the life of a woman who trusted him completely. The defense was led by a barrister named David Forsyth, who was equally good at his job and made the only argument available to him: that the evidence was circumstantial, that the forensic document analysis was contested, that the toxicology was not sufficiently conclusive to establish causation, and that the relationship between a son and his elderly mother, however complicated in retrospect, was not a criminal enterprise. Forsyth's opening was effective. He was right that the evidence was partly circumstantial. He was right that the toxicology involved complexity that created genuine uncertainty. He reminded the jury, carefully and more than once, that it was not sufficient to believe Ryan Calloway had done something wrong. The standard was beyond reasonable doubt, and doubt, he said, existed in every element of this case. For the first 3 days of the trial, I think an honest observer would have said the outcome was genuinely uncertain. Then the pharmacist testified. Gul Hassan had been the dispensing pharmacist at the Holbrook Road Pharmacy for 12 years. He had known Margaret Calloway as a customer. He testified that he had a specific policy of adding handwritten notes to prescription records when anything appeared irregular, and that he had added such a note to Margaret's file in January 2019 when Ryan had collected the 3rd lorazepam refill. The note read, queried with customer's son, stated GP had increased dosage, unable to verify at time, noted for follow-up. The follow-up, Mr. Hassan testified, had never happened. Margaret had died 3 weeks later. He had kept the note. He had not destroyed it. He had not overlooked it. He had maintained it in the pharmacy's records because he had been trained to document anomalies, and an unexplained refill request was an anomaly. Catherine Aldridge held up the photocopy of that note and presented it to the jury without comment. She let them read it. She let them sit with it. There was no increased dosage instruction in Margaret's GP file. Dr. Sharma had not changed the prescription. The refill in January 2019 had not been authorized by a dosage increase. The medication had been collected using an explanation that was false. Forsyth cross-examined Mr. Hassan for 2 hours. He challenged the record-keeping system. He suggested the note could have been made after the fact. He established that Mr. Hassan could not have known in January what would happen in February. None of it dislodged the note. None of it changed what it said or when the pharmacy's system had time-stamped it. Then there was the text message. Catherine Aldridge read it to the court on the 5th day of the trial. She read it slowly. She read it once and did not reread it. Ryan had sent a message to Gary Pollard on the 26th of December 2018. Christmas had just passed. Margaret had been alive. She had been in the house. The message, in the context of a longer exchange about Ryan's plans for the coming year, contained the following sentence: "Once the house situation resolves, I can finally start actually living." Ryan told anyone who asked that he'd put his whole life on hold to be there for her. And by the time she needed him most, he never left her side. That sentence, which had sounded in the first act of this story like the portrait of a devoted son, lands here with its full and terrible weight. Once the house situation resolves. Not once his mother had recovered. Not once the arrangement had run its course. Once the house situation resolved. Margaret Calloway, 82 years old, living in the house she had kept for 44 years. She was, in her youngest son's private language, a situation to be resolved. The jury had been attentive throughout the trial. They became very still when that message was read. Ryan Calloway testified in his own defense. He was composed. David Forsyth had prepared him well, articulate, and specific. He maintained that the will was legitimate, that Margaret had asked him to arrange it, and that he had done so through a solicitor whose subsequent loss of professional registration. He acknowledged, raised questions he could not fully answer. He maintained that the medication records reflected a verbal instruction from Dr. Sharma that had not been formally documented. He maintained that the December text message reflected the stress of his situation, not a plan. He wept twice during his own testimony, once when he described his mother's final days. Once when he described the moment he learned the police had opened a criminal investigation. He held a handkerchief. He looked at the jury when he was composed enough to hold their gaze. Patricia sat in the public gallery and watched. There is something exhausting and clarifying about watching someone perform grief inside a courtroom. The people who know the story, who have lived in it for 2 years, see the performance differently than the jury does. Patricia would say later that watching him cry was not the hardest part of the trial. The hardest part was not being certain whether the jury saw what she saw. Catherine Aldridge's cross-examination of Ryan Calloway took 4 hours. She did not raise her voice once. She worked through the care diary entry from the 13th of February with the patience of someone who had read it 500 times and knew exactly where it went. She placed the bank timestamp beside the diary entry and asked Ryan to explain the 17-minute gap. He said he may have made the transfer earlier and entered the diary note later. She asked why, if the sequence was innocent, the diary note was written in the past tense and carried a specific time reference. He said he could not account for the precise form of every entry. She asked whether he could account for the specific wording. He said not precisely. She then read the December text message aloud again. She looked at Ryan. She said, "The house situation. What situation were you referring to, Mr. Calloway?" He said, "My own situation. My financial situation, nothing more than that." She said, "You were living in the house." He said, "Yes." She said, "Your mother was alive." He said, "Yes." She said, "The house was not yours." Long pause. He said, "Not yet." Not yet. The phrase sat in the courtroom for a long time before anyone moved. The jury retired on the 30th of September 2021. They returned the fraud and forgery verdicts by the end of the first day, guilty on both counts. Those verdicts were not surprising to anyone who had followed the trial. The gross negligence manslaughter verdict took 3 more days. The jury sent a note on the second day of their deliberations. The note asked for the pathologist's report to be reread to them in its entirety. They asked, specifically, about the distinction between evidence of accelerated death and evidence of intent. They were working through the question that everyone who followed this case has had to sit with at some point, because the manslaughter count does not require proof that Ryan intended his mother to die. It requires proof that his conduct was so negligent that it constituted a crime. And here is the detail I think the evidence raises but does not, even now, fully answer. We know the medication was over-administered. We know Ryan administered it. We know he collected more than was prescribed. What we cannot know with the certainty the law requires is whether he did so knowing it would shorten her life, or whether he simply did not care. And I am not sure those two things are entirely different. But I wonder what you think. On the third day of deliberations, the jury filed back in. The atmosphere in the courtroom was the specific tension of a room full of people who have been waiting for something for a very long time and know it is about to arrive. The foreperson was a woman in her mid-50s with reading glasses pushed up on her head and a folder in her hands that she didn't need. Because the verdict was not in the folder, it was in her voice, and she knew it, and the room knew she knew it. The judge asked for the verdicts. Fraud by false representation. Guilty. Forgery of a testamentary document. Guilty. Gross negligence manslaughter. Guilty. Ryan Calloway stood completely still in the dock. He did not cry. He did not look at the jury. He looked at a fixed point somewhere above the public gallery and held it for 5 seconds before his solicitor touched his arm and said something quietly into his ear. Patricia was sitting in the second row of the public gallery. She would tell the press, in a statement she had written weeks before because she had learned the hard way across 2 years of this to prepare herself for every possibility, that she felt nothing immediately. Not relief. Not justice, not the resolution she had spent 2 years pursuing. She said she felt the specific blankness of someone who has spent so long waiting for a thing that the arrival of the thing is less like an ending, and more like the moment a sound you'd stopped hearing finally stops. Brendan was not in court. He had been there for the first week and then he had not been able to continue. He found out by phone. Patricia called him. She said all three. He said nothing for a long moment, and then he said right, and that was all. The investors, D.C. Ockhafer and D.I. Reeves and the rest of the team who had spent 14 months building this case, were in the corridor outside the courtroom when the verdict was delivered. They heard the quiet from inside the room before anyone came out to tell them. D.C. Ockhafer would say, in an interview she gave after the case closed, that the quiet was the thing she remembered, the particular quality of a silence that meant it had gone the way it needed to go. Ryan James Calloway was sentenced on the 18th of October 2021. Judge Helen Watts, a different person from Patricia's solicitor, sharing the name without sharing anything else, addressed him for 45 minutes before arriving at the sentence. She noted his genuine early care for his mother. She acknowledged that he had, in the beginning, provided something real. She said that acknowledgement made what came afterward not less criminal, but more comprehensible. That the care had been the foundation of the transaction he had constructed in his mind. The justification he had used to convince himself that what he was taking was not stolen but owed. She noted that Margaret Calloway had died in her own home, cared for by her son, afraid of something she did not finish naming. She said 11 years. The house on Holbrook Lane, the house that had been in Ryan's accounting, already his, was returned to the estate and distributed under the 2014 will authenticated by Karen Doyle and verified by 2 independent probate experts. The investment portfolio and the proceeds of the savings account, which were recovered through the civil proceedings that ran parallel to the criminal trial, were also distributed equally across the 3 beneficiaries, 1/3 to Patricia, 1/3 to Brendan. 1/3 to Ryan's share, held in trust pending the outcome of various civil proceedings that would outlast the criminal sentence by several years. The house sold in April 2022 for £241,000. Margaret had lived there for 44 years. She had kept Dennis's Valentine's card in the top drawer of the bedside cabinet. The new owners found it. They had no idea what it was. They threw it away. Patricia Calloway gave a statement to the press outside Coventry Crown Court on the day of the sentencing. She had written it the night before. She read it from a piece of paper and did not look up until she had finished. She said, "My mother was a good woman who trusted her son and deserved to die in peace. I am glad the court reached the verdicts it did. I want to be honest and tell you that winning this case feels almost indistinguishable from losing it. Because what we won was the truth, and the truth is that our mother spent the last weeks of her life in fear, and nobody came in time. Not the courts, not the police, not us. Nobody came in time." She folded the paper. She walked back to her car. She did not stop for questions. Ryan Calloway had spent his adult life accumulating losses. The businesses, the marriage, the flat, each failure had been real. Each one had cost him something genuine. And when he moved back into his mother's house and became, for the first time in years, useful, needed, present in a way that felt like value, that was real too. The care he gave in those early months was not performance. It was not strategy. It was a man who had failed at everything else, discovering that he was good at this. That he was necessary here. And somewhere in that genuine care, something curdled. Because the house was there, and the money was there. And Patricia and Brendan had their stability, Patricia with her NHS job, Brendan with his firm in Leeds, and Ryan had nothing that was securely his except the arrangement that had become, across 18 months, his entire world. And the world was finite, and the end of it was coming. I don't say this to excuse him. I say it because the truth of what human beings are capable of is not usually simple. It is not usually the story of a cold predator who never felt anything genuine. It is more often the story of something real that became something else, love that became entitlement, care that became control, grief at one's own circumstances that became, with catastrophic logic, the permission to act. Margaret had a fear she didn't finish naming. That is the sentence I cannot move past. Everything else, the fraud, the forgery, the locks, the medication, the text message, the diary entry, all of it is documented and prosecuted and sentenced. But that half sentence in Dr. Sharma's notes in November 2018, that is the part that has no resolution. That is the part the law could not reach because the law requires evidence, and that sentence was never completed. What she was going to say is something no verdict can return to us. There are families sitting right now in solicitors' offices, in probate courts, in mediation rooms, in the specific unhappy silence of dinner tables where an estate has become the thing nobody can stop talking about. And most of those stories will end in legal agreements and fractured relationships, and the particular grief of knowing that the person who died would be heartbroken by what they left behind them. Most of them will not end here. Most of them will not reach a courtroom where a forensic document examiner and a pharmacist's handwritten note and a 17-minute gap in a care diary change the nature of the story entirely. But some will, and the ones that do share a common architecture with this one. A closed household, a single carer, an elderly person whose ability to speak freely to the outside world narrowed over months until it was managed by the one person who stood to benefit from their silence. Margaret Calloway trusted her son. She had every reason to. She had watched him fail and rebuild himself 3 times, and she had not withdrawn her love across any of those failures. And when he came back to her house with his life in pieces, she had opened the door and been glad to have him close. That is the thing that no sentence and no redistribution of the estate can address. She was glad to have him close. And he never left her side.